Um, Good day. So for today's lesson title will be Privacy of Communications and Freedom of Speech and Information. So let's go with the main lessons. Privacy of communication and correspondence are the rights of privacy is the right to be left alone. Um, it is the rights of a person to have time for himself, to have self-preservation, and to have to be left alone, to have his own comfort. Next is the basis of purpose of the right. So first is right existing in the states of nature. So right is inherent. It is given to us and its nature. Next is the right designed to secure the enjoyment of one's private life. So this is to secure the enjoyment, to have the rights to live, have the rights to choose to be happy, or to choose whom to love, which involves the enjoyment of one's private life. Next is the relationship with right against unreasonable searches and seizure. So first is the aspect of the right to be secured in one's person. So our rights is secured by ourselves. That is inherent to us and secured as it belongs to the individual. Next is privacy of communication and correspondence. So there is a privacy or a um, confidential thing that secure the communication and correspondence. Or when we say correspondence, it is defined as the communication generally and in a written form. So next is the scope of protection. So these are the rights covered with the all forms of private communication and correspondence. Next will be the limitations on the right of privacy and communication. So first is permissible interference. So permissible interference, these are the observed or predicted interference. Next is upon lawful or order of the court. So these are the legal disposition of the court. Next is when public safety or order requires otherwise as the law prescribe. So when the court requires the safety orders to be regulated, to be, I mean, to break when needed for apprehension, especially to the offender. Next is the intervention of the court. So these limitations where the interference of the court is limited. Next are the freedom of speech and expression and of the press. So in Article 3, Bill of Rights, Section 4 of the 1987 Philippine Constitution, no law shall be passed abridging the freedom of speech and expression or the press or the right of the people of peacefully to assemble the petition of government for redress or grievance. So this is the rights to the no shall the government or the law shall shatter an individual's freedom and rights to freedom to speech and of expression. So next will be the scope of terms, speech, expression, and press. So speech and expression covers form of oral utterance. So when we say oral, when we say speech or express, it was come out orally. It is verbally, which expresses your opinion. Next is the press. So the press covers any sort of publications as instruments of for mass communication. So examples of this are the reporters. Note that freedom of expression is not an absolute right. So next is the limitations Limitations, I'm gonna read the limitations. It's subject to regulation by the state. Number two is subject one to liability when abused. So next will be the four aspect of freedom of speech and press. The freedom of censorship or prior restraint, the freedom from subsequent punishment to publication. Next is the freedom of access to information regarding matters of public interest. And fourth is the freedom of restriction. So next is the test valid test for valid restriction. First is the dangerous tendency doctrines. It permits the limitation on speech once a rational connection has been established between the speech and restrains the danger of the completed. So, in the words uttered, created dangerous tendency, the states have the right to prevent it. So that is the dangerous tendency doctrine. So in balancing of interest test, it is used the standard when courts need to balance conflict and conflicting social values and individual interests. So, and it requires conscious and detailed consideration. So, in the interplay of the interests observable in a given situation. So, it requires that determination must be first be made whether the necessary safeguarding of the public interest involved may be achieved with some measures that is less restrictive than the protective freedom. Next is the clear and present danger rule. Rests on the premise on the speech that may restrain because there is substantial danger that the speech will likely to lead an evil the government has the right to prevent. So when it causes evil or it or when it leads to an evil, the state has the right to prevent such act.